and welcome back to many of you. For those of you joining us for the first time, I'm Maggie Mahan, the Assistant Director for Advancement and Engagement with the State Historical Society of Missouri. Thank you so much for joining us today. As the coordinator of the Cape Girardeau Research Center, Bill Eddleman presents the next installment in his genealogy series. Today's program is focused on researching non-standard federal lands. If you need to catch up on previous installments of Bill's genealogy series, today is the 16th episode. Or if you would like to rewatch any of the segments, you can view them on demand on the State Historical Society of Missouri's website at shsmo.org. All events in our virtual programming series are made possible thanks to the generous support of the Society's members and donors. You can visit our website to learn more and see how you can add or renew your support. Welcome, Bill.
Thanks, Maggie. I'd like to welcome everyone to this installment of the genealogy series. I think we've called it basic genealogy, but we're starting to get maybe a little bit beyond basic genealogy into a little bit more specialized sorts of research. And so what I'm going to talk about today is ways that our ancestors acquired land that are a little bit out of the ordinary. Earlier, we talked about obtaining first title and how that occurred in state land states by land grant, typically, and in federal land states by purchase from the government. But what we're going to talk about this time is state land states only and non-purchase arrangements, or if they were purchase arrangements, they were purchased in a different manner. So that's why I've called it, because there's a lot of different categories here: salt, schools, swamps, military bounties, and homesteads. So we'll talk about a few others beyond that as well. So just to review, the typical route to getting land for most people in a federal land state was, first of all, the land had to be cleared. That is, the tribal land rights had to be extinguished. And you could debate the lack of morality in this whole step endlessly, but that was an essential first step. It had to be free and clear U.S. government land. Then the land was surveyed. It could not be dispersed and sold until there was a survey to describe the land. Then our ancestors would have gone to a local land office and viewed parcels in a tract book. They may have already been on these parcels prior to the survey, but they needed to make it official and they needed to make it legal. So they viewed the parcels and they would enter them if need be. The land then became offered for sale, either by credit early on or by cash, and there was a file established. And these files are all in the National Archives, and you can request them for a price, or you can go and do the research in person to look at these. Most of them are pretty uninteresting. There are some that are interesting. Then the payment was completed, and the last document for that payment was included in the file. Paperwork was sent to the General Land Office, and then they issued a patent, and the land was yours. So the patent was sent to the land office to be picked up. Most of them were picked up by the original landowners. Some of them were not and are still in the National Archives in that sale file. So if I go through the usual routes and I find my ancestor got land, but I can't find how they got it. Sometimes land was transferred from the government to private ownership differently, through a different route than this land office route. Or if it was through the land office, it was done in a different manner. The reasons for that include Congress oftentimes granted lands to the state to sell for specific public purposes. You're dealing with a time period where the federal government chronically had no money. One of their primary ways of getting money was to sell land. If they wanted to help the states out, again, federal government had very little money. Their best way to help out the states to do things would be to allow the states to have certain types of land, and then uh, the states could sell it for specific purposes. Sometimes, same sort of idea, the federal government owed money or owed compensation to individuals. And again, the best way to do that was to let them have land in exchange for those services. A lot of this boils down to military service. So if we're researching these sorts of things, they require different research strategies than the typical research strategy. So first of all, the first type of land that you see in most of the federal land states, and this is really probably one of my most Missouri-centric presentations because it varies so much from state to state. And so if you're researching in a different state, I'd suggest either looking at the Family Search Wiki for land, it might be in there, or contact the state archives or the state library and ask them about this. But most of the states had school land. Well, what is school land? It was usually provided for in the States Enabling Act, and the land was granted to the state and sold by the counties to fund township schools, local schools. Again, the federal government wished to encourage education, but they didn't have any money, so they just included land when the State's Enabling Act was passed. Typically, that's Section 16 out of each township. And if you can't remember how the townships were set up and how the land was set up, I'd suggest you go back and review that original title presentation where I talk about that. Now, sometimes Section 16 was unavailable. It was either in the middle of a swamp or in the case in Missouri, especially in the counties along the big rivers, Section 16 might be part of a confirmed Spanish or French land grant, in which case, when they set up the survey for that township, they would look for additional land to get up to 640 acres, which is the size of a section, in other sections. So I've seen as many as 3 or 4 sections in part included in this school land. And it helps explain a lot too. They'd sometimes even go to adjacent townships to piece it out. So if we look at a township, Section 16 is right in the middle there. It doesn't mean they built the school on Section 16. It just means the land that was sold in Section 16, the proceeds were used to fund the school. The school may have been anywhere. And I know the typical situation is some individual would have donated a small parcel of land, maybe an acre or thereabouts, to build a school in the township. Or there may have been more than one school in the township. It was a higher population. The records of these and the patents are at the Missouri State Archives for Missouri. You may also find records, even if it's a ledger, in the county clerk records at the county level. So to locate these, first of all, the records are on the Missouri Digital Heritage. And we'll talk here in a minute about Missouri Digital Heritage. They're searchable, and the images of these patents for school land are available online. Any of these land titles may be recorded also in the county deed books, although that was not a requirement. A lot of times, individuals who bought the land would want it recorded in the deed book. So check the indirect deed indices for your ancestor, who would have been the buyer. The seller would have been the county, sometimes the state, and you find all sorts of things indexed under the county and the state. So the Missouri Digital Heritage is a project of several state-level entities. I know State Historical Society of Missouri has contributed some records. A lot of them are Missouri State Archives, but it is available under the umbrella of the Missouri Secretary of State. So it's kind of a project mostly of the state archives. So I'm going to look at one individual who bought school land. His name was Samuel Vansel. And so if you go to the Missouri Digital Heritage and click on land records, you'll get a search screen that starts out with the name of the individual, a year range, and then there's additional things you can fill in when you do your search. So here's the whole thing. If you're just looking for certain locations, you can restrict it down to section, township, and range. This particular search page is for a variety of different land records. So when you select a series, you would select school land if you're interested in school land, and then if you're interested in a specific county. But a lot of times when you're looking for an ancestor, you don't want to restrict it that much. So here's the pop down for the series, and you can see there's a bunch of things. Most of these I'm going to talk about, so don't worry about it for now. So I'm going to look for Samuel Vansel, and I'm interested in township school lands. And he actually bought 3 different parcels from township school lands. I can click with the school lands, I can click on view details and get the information about more specific location, how much he paid for it, when he got the certificate, and so forth. But I can also click, if you notice up in the upper right, I can click on, always have this problem that the view images. And lo and behold, I get a copy of the patent. But look at details of that. It gives the location, it gives Samuel Vansel's name, and how much he paid for it. It's all the information that was transcribed in the earlier screen. A second category of land had a different function. These were seminary and saline lands, and those were pretty early on in the state of Missouri, at least. And they're included also in the Missouri Enabling Act. And what those were for, first of all, seminary lands. Seminary lands were up to 2 townships, that's whole townships, donated to the state for use and support of a seminary. And a lot of people get it in their head that seminary is a religious school. It's the meaning at that time was any higher education institution. So in other words, this would have been to fund a higher education institution at the state level. The land was to sell for not less than $2 an acre. Saline lands, there were up to 12 large salt springs with 6 sections of lands attached. These were set aside for the state to sell because they were more highly valued because you could mine salt there. And so 5% of the net proceeds were designated for creating public roads and canals, that is, internal improvements. So this was something to provide the state a funding source for public roads and canals. Of course, in Missouri, we didn't build many canals, but we did build public roads. These were the ones that were designated. I don't think a total of 12 were actually designated, but they were in Pike, Rawls, Cooper, Saline, and Howard counties. These are also indexed in the Land Records Database in the Missouri Digital Archives. The patents are not digitized, and they contain very little genealogical information. Again, the index on the Missouri Digital Heritage, the patents are on microfilm. So you can go to the state archives and ask for the microfilm and look at those images. So we'll go through an example here. We're going to click on seminary and saline lands. Then we're going to look for a guy named Lewis, William Lewis. And lo and behold, he purchased 5 different parcels of seminary and saline land in Jackson and Saline counties. And I can look at the details, and I get the same sort of screen as I did for school land. And here's what a patent looks like. I actually went to the state archives when I prepared this talk in order to get images of some of these that are available on microfilm or CD. So here's what one looks like. It's all handwriting. This is not William Lewis, it's Brian Baxter, but it's the same sort of thing. And it specifies that under this act for seminary lands, and his was seminary land. Same sort of thing for William Lewis's saline land patent. And again, it specifies it's saline land. The next category of non-typical federal land acquisition is the 500,000 acre grants. These were authorized. There was an omnibus federal law that most of the time when you hear it mentioned in genealogical circles, they talk about this as the Omnibus Preemption Act, or just the Preemption Act, because this was the Preemption Act that kind of superseded all the others. And it was for providing for people who were already on land when it was surveyed so that they would get the first shot at getting title to the land and purchasing it from the government. So it kind of codified all preemption rights. There were tons of other preemption acts before this. So these 500,000 acre grants authorized payment to several states, 10% of the net proceeds of sale of public lands. For all public lands went to and this was part of the act, went to these states, including Missouri. But each of the states was also granted 500,000 acres to be selected by the state's legislatures to fund internal improvements. Each state, at least Missouri, selected a board of commissioners to determine the location. So the 500,000 acre grants were in Platte, Buchanan, Andrew, and Holt counties. The land was removed from sale at the U.S. Land Office. You could buy up to 160 acres, and it was either heads of families, widows, or single men over age 21. These are also indexed on Missouri Digital Heritage, and again, for internal improvements, which that's another word or phrase for roads, canals, and other public works. These are indexed again on the Missouri Digital Heritage, and in this case, the originals are digital files on CD at the archives. So I'm going to look for a guy named Stevenson who got a 500,000 acre land grant, bought it. Hiram Stevenson, and he bought quite a bit. Probably all, he only bought one 500,000 acre grant in Clinton County in that parcel. All of these others are probably just regular land office sales. So here's the details on his 500,000 acre grant. And here from the CD is an image of the patent. He was from Clinton County, which that would be valuable information if you're looking for this guy. And it gives the location of the land and, again, his name and when he purchased it. Okay, so far we've mostly talked about pretty restricted locations. School land was in every township, but again, it was only Section 16, except in certain instances. Now we're getting into something that is irregularly distributed, but can be very, very important. For example, if you do any research on an ancestor in the Missouri Boot Heel, you are going to have to deal with swamp and overflow land sales, probably, because so much of the land was swamp and overflow. When they originally surveyed the land for the U.S. Government Land Office, they designated flood-prone lands, which they termed swamp and overflow lands, and those were generally deemed to be of low value because you couldn't farm them. They would flood seasonally or semi-permanently or permanently. And so they realized when they were doing the survey, we can't really sell this very easily. And they tried selling swamp and overflow land at the land offices, and they didn't make much headway. So, being very magnanimous, Congress granted these swamp and overflow lands by the Swampland Act of 1850 to the states for them to sell. It's kind of like, I guess, I got a white elephant, so I'm going to give it to somebody else to deal with. And the state attempted to sell it. They sold some parcels, but in 1852, I think the state started to realize they couldn't sell it very easily either. So they transferred the land to the counties. And so a lot of the records for these swamp and overflow lands are going to be at the county level, although they deposited a lot of the records at the state level. So a lot of it's at the Missouri State Archives. Okay, here's pertinent pieces of the Act of 1850. Many of the sales for the Boot Heel counties are in the Missouri Digital Heritage Land Records. I think I've pretty much ascertained and determined that not all of them are in the Missouri Digital Heritage. Some of them you're going to have to get to the county level records. Digital copies are available in the research room. So again, you got to be at the facility to get the images. Later records include listings at the county level. Many counties have ledgers. They may have listings in deed books. They may have individual deed records where the county sold the land to individuals. This is commonly found. I do a lot of work in Stoddard County, constantly find deeds where the county is selling swampland to individuals. There was also a program of preemption for swampland, and they had to provide testimony as to what they'd done on the swampland before they could get a reduced rate and buy it. So you'll find these records at the county level, and you'll also find them oftentimes, they've been microfilmed, and they're at the Missouri State Archives under the county clerk's files. But there's something that Missouri State Archives, bless their hearts, I love this resource, Missouri State Archives County and Municipal Records database. What this is gradually they are making available digitized images of records they have microfilmed that are not available otherwise. They're either available in microfilm or in the original form at the county courthouse. But now many of these are becoming available online through the Missouri Digital Heritage County and Municipal Records database. So a few ways to get at some of these records. First of all, we can do the same thing we've done with these other non-typical records. We can go to the Missouri Digital Heritage Land Records search and search for swampland packets. And I'm looking for, I think it's Elijah Norman. And he purchased a couple parcels in 1857 in Stoddard County that ended up in the state database. And again, I can view details. And I can get the original from a CD in the Missouri State Archives. Now, in terms of these preemption claims where there's lots of testimony, and I can't emphasize enough, if you have an ancestor that got one of these preemption claims and had to file testimony, you're going to find all sorts of gems in that testimony. The trick is finding the testimony. Some of it is still only available at county courthouses. Most, I think, has probably been microfilmed, but I suspect not all of it. So you go to county clerk records and a lot of it is becoming available on this county municipal records database. So what I'm going to do is I'm just going to look for Cape Girardeau County, and you're going to look under county clerk records because that's where these are usually kept, and just miscellaneous. And lo and behold, under miscellaneous, I've got various swampland records I could look at, but then I've also got swampland preemption claims, 1858 to 1865. And if the image link is lit up, that means you can look at the original document images. And this one is for an individual named Albert P. Keeling. And it's the testimony for him to file for preemption on swampland in 1858. He had to document what he'd done. And so he had to pull people in as witnesses, or the county did. And in this case, Isaiah Poe Jr. comes in and swears that Keeling had built a house by July 1858. Not only that, it was a log house about 20 by 22 feet made of round logs, partly something down and out to about 9 or 10 feet high, covered with clapboards, nailed on, plank floor, a door and shutters, partly chinked, partly lined with boards. I think you get the idea. If I had this level of detail on many of my ancestors' houses, I'd be really happy. But also, he'd answer questions. And one of these was, do you have a family? Yes, I have a wife and 2 children. Bingo. In 1858, he had 2 children and was married, and his wife was alive. And did he have other land that he'd located in the state? He did not, but he resided on rented land, but preceding his removal to the swampland. So all sorts of details in these files, if you're lucky enough to have one. Again, you can find some of these in the county deed records. If you do look for these, I would suggest a research strategy. Look at the grant index for either Missouri or state of Missouri or the county name. So if I were searching Stoddard County again, I'd look under S for Stoddard County, and I'd try S for state of Missouri, but sometimes indexed under M for Missouri. Note the dates and read the deed. Make sure it's not a delinquent tax sale or some other reason which the county or state would have sold land. So again, swampland, of the ones I've talked about so far, you're most likely to encounter this so far. That being said, I don't have any ancestors that bought swampland. I do have an ancestor that I think bought a parcel of school land. Couple others that you probably heard about before that are non-standard ways of getting federal land. And the first of these is the Homestead Act. Now, this being said, people throw around the term homestead far too liberally. I had somebody correspond the other day and said something about their French ancestor got a land grant where St. Louis, downtown St. Louis is. And I always wondered if they homesteaded or if it was a land grant. And I'm like, this is 1780. Homesteading did not exist in a formal way. I use the terms grant or squatter or preemption. Homestead shouldn't really be used in your vocabulary in genealogy until 1862, because that's when the Homestead Act was passed. This was actually people when you talk about the founding of the Republican Party, this was one of the things that was their cornerstones from the time they were founded, is something like the Homestead Act, to get land more easily into individuals' hands who were willing to work for it. You're going to find the records in the National Archives in Record Group 49. Hung up there. Okay, what about Missouri? When I first started, being interested in this sort of thing, I thought, well, when you hear about Homestead Act, you're thinking Western states. Missouri probably didn't have any or didn't have many, but actually, as it turns out, there was still quite a bit of unclaimed land or unpurchased land in Missouri. In total, there were 34,633 homesteads proved in Missouri. Proved means the people actually jumped through all the hoops and got the title to the land. The total acreage homesteaded was 3,644,306 acres, which is 8% of the land in the state. So it was a much bigger deal in Missouri than many people think, me included originally. One example is a guy named Isaac Wright. And because of the timing here for most homesteads, he was a freed enslaved man. So he had quite a good reputation. He supported people on adjoining properties during the Civil War. In 1865, he applied for a homestead at the land office in Booneville, and his 80-acre claim in Newton County lay adjacent to his former enslaver William Wright's farm. He signed his own name, so he had learned how to write in that length of time on the final affidavit in 1870. Who was eligible for homesteads? Non-citizens were excluded. Ex-Confederates were initially excluded, but were allowed later, probably if they had sworn the loyalty oath. And then probably that went away after a time, I'm guessing. Most Native Americans were excluded, and foreign-born Asians. 160 acres was the amount of land. It was to be on unappropriated, unoccupied, unreserved land. Land reserved for government purposes, Native American lands, state and territorial lands, valuable mineral lands, timber lands, private land grants, and railroad grants were excluded. The procedure for qualifying: first of all, residence. You had to be on the land continuously in a home. You had to have created improvements that showed good faith to live on the land. You had to show evidence of cultivation. So again, that's good faith, living on the land. We're going to actually go through with this behavior. Commutation was allowed. You could pay a minimum price per acre before 5 years if evidence showed proof and settlement of cultivation. You could also use, as part of the purchase price, a military bounty land warrant that we'll talk about here later. File proof: at least 5 and no more than 7 years after entry, you had to prove that you had actually done this. And then you were issued a patent if you qualified. And they were pretty good about examiners for claims that people had actually done this. Oftentimes, entries were either relinquished voluntarily or canceled by the General Land Office. Cancellation could be by reason of abandonment, failure to fulfill a requirement, or evidence of bad faith. Many people tried to cheat on this. Most of them were caught and the claim canceled. Applicants were entitled to a hearing for cancellation. Well, how do I find out if my ancestor actually got homestead land? Well, one way is when you go to the General Land Office search page. Again, we talked about this in an earlier presentation. I'll have some examples here as well. But when you go to that search page, I would, first of all, unclick search patentees, and then you go down to the authority down at the bottom, click on that, and you can click on Homestead Entry Original. And it will indicate who got homesteads. In this case, I'm doing a search for Cape Girardeau County. And the result is, and I didn't think there'd be any because I thought, man, Cape Girardeau County, it's been settled since the 1790s. Surely all the land was taken up. Nope, there were something on the order of, I believe, 30 different people that qualified for homesteads in that county. Another way you can tell if your ancestor got a homestead, if you have a copy of the patent, take another look at it, and if it has this image up in the upper left, that is a homestead patent. They didn't use that image on regular patents. So that's a quick, fast way if you've got a copy of the patent. If you're going to research homesteads, and there is some marvelous information in homestead land case entry files, this is not like your regular land office case entry file where most of them are pretty uninteresting. Every one of these I've ever looked at is pretty interesting. It's got a lot of detail. So it's very likely to have family information. You're going to need the patent number if it was completed. You can get that off the General Land Office website, the Glow Records search page. You can obtain copies of the entry files using National Archives Form NATF 84. Somebody told me the other day they're not allowing you to fill that out online, and I checked, and it looks like they are. So I think you can still do that online. If not, mail it in. And again, I mentioned you can use the authority block to look for patented homesteads and get more details that are needed on the Form 84. So here's one example, and it's testimony of claimant, and there's a lot of blanks, and boy, there's a lot of detail. And this particular individual, who was Elizabeth Creve, I think, she and her husband started the process. He died, and she managed to finish the process. She had help from some of her relatives in qualifying. But her husband, at least, and probably her, were immigrants, and she had his naturalization papers. So that's the first arrow. The structures they built on the land that indicated settlement, they built a house. And because her husband died and she was getting elderly, she was boarding with her grandsons at intervals. Because she was unable to stay on her own all the time. And then she indicates when her husband died and that he lived on the land until his death. There's more detail on structures on the site and all sorts of other detail, exactly what was planted. So these things are really wonderful for the amount of detail, and you learn a lot about the ancestor by looking at them. So again, if you have an ancestor that got homestead land, by all means, get that land case file. The last major one I'm going to talk about is military bounty land. And again, this was a situation where the government didn't have money, but they had land. And so they paid off people in land. And the way it first started was during the War of 1812, land warrants were used to pay troops. The government literally almost had no money. And so they offered up land warrants in some cases for enlistment. They were used in every war through the Mexican War, and they made them retroactive even for Revolutionary veterans. There are a lot of different congressional acts, so pay attention to one key thing: were warrants assignable? Because for many of these, they didn't allow them until veterans were relatively old. And the whole idea was, well, we want people to settle on the public land, but these men, a lot of times, were not going to move. They were older and didn't want to move. So they didn't really go for the land warrants because they couldn't do much with them. Congress finally realized this and made them assignable. And that's when the floodgates opened up and people got the warrants and then would sell them to agents and assign them. So a lot of times, if your ancestor got bounty land patent, they may not have been the veteran, but they got the warrant from an agent or someone else who had qualified. There were acreage limitations at various times. Eventually, the goal was 160 acres for everybody. Congress just gave up and made it 160. So this is important for War of 1812 because most people got 2 of them, because initially it was only 80 acres for veterans, and then they upped it to 160. You need to know who was eligible and under what circumstances, whether heirs could inherit the bounty land warrant, or whether there were age limitations and rank limitations. So look at the laws, look at the acts. The first, one of the first efforts was War of 1812 military reserves. These were places where the men that were paid in warrants for their service could cash them in. They initially didn't want them just anywhere. They wanted them in specific areas. So Congress made 3 2-million-acre designated tracts for use of the warrants. One was in Michigan, one was in Illinois, and one was in Arkansas. And I'll add that by 1842, if anyone was still holding one of those warrants, that restriction was lifted and they could cash it in anywhere in the public domain. It became very obvious quickly that the Michigan tract was a worthless forested swamp, primarily, useless for farming. And so they replaced that with a 500,000 acre tract in northern Missouri in 1816. This tract is in Randolph, Macon, Sheraton, and Carroll counties. You can search for these on the General Land Office records site, and we'll go through the whole thing. This is what the splash page looks like. You click on search documents and you get this screen. And for these military, War of 1812 military reserve, you're going to want the Scrip Warrant Act of 1812 under authority in the lower right. And I'm just going to search in Missouri in that 500,000 acre chunk. And I get this. Typically, what you see is a whole bunch of land parcels where the patentee and the warrantee are the same person. I will tell you, genealogically, other than the fact that it locates land, these are not all that interesting. The ones that are interesting and where you get relationships is where the names differ. So we'll look at one of those. Right there, the warrantee was Casper Barr, but the land was patented to Henry Barr and Catherine Septry in Sheraton County. And every time I see one of those, I automatically think, okay, that's a relative, and it is in this case. Henry Barr and Catherine Septry were the brother and sister and only heirs at law of Casper Barr, deceased. Usually what that means is that the warrantee had died. In this case, in these Scrip Warrant Act of 1812 cases. So if you're lucky enough to find one of those, and one of the families I was researching, actually, I've got one of these from a North Carolina veteran, where his brothers and sisters inherited and he never married. Okay, so other bounty land acts. In 1847, again, they declared war against Mexico and the government had no money. So they right up front said, okay, anybody that enlists gets a 160-acre land warrant if they serve 12 months. So that was in 1847. Soldiers serving in the War of 1812 and Indian Wars from 1790 onward were granted warrants for 80 acres for 4 months service in 1850, 160 acres for 9 months service. These were not assignable again, so they weren't very worthwhile for many of these old men. And so they were later made assignable, in which case they did attain value. And there were, if you have a War of 1812 veteran who lived into the 1850s, they almost certainly got one of these or two of them. In 1855, all soldiers in all wars were granted up to 160 acres, which means any of these people under the Act of 1850 who got 80 acres could now get another 80 acres. So my ancestor that was in the War of 1812 had two of these because he was paying attention and realized I can get another one in 1855. It only took 14 days of service to get the 160 acres in that act, and these were fully assignable. Did your ancestor receive bounty land? Well, when you go on the General Land Office search page, don't specify a location, uncheck search patentees, or you can search for an ancestor using one of the Scrip Warrant Act authorities. I'll use my ancestor, Henry Eddleman, as an example. I'm going to look at any state, any county, uncheck patent search patentees, leave warranties checked, and just leave it any authority. And lo and behold, there you go. He got one. He actually got two, but his name only appears along with his wife's on the second one because she sold it after he died and someone else named Conrad cashed it in. So there's all the various Scrip Warrant Acts. And by the way, this was also available for widows of Revolutionary War veterans. I've seen several examples of that. Again, there's an application file for these bounty land warrants, and these are very valuable. They have the most valuable genealogical information you can imagine. Claims had to be proven. So you had to prove things like, yes, I got married, I am this person, and I did this service, and I got married in this day. And if heirs were filing for it, yes, here's why I'm related to the veteran. And so and plus they have really good stories in them. I'll give you an example. The bounty land files were oftentimes merged with pension files. So for bounty land, use the form requesting War of 1812 bounty land files for that. Unfortunately, not very many War of 1812 veterans got pensions because they didn't pass the Pension Act till 1870. So they're usually just bounty land files. I might also add that if you want to contribute to a really valuable genealogical cause, National Genealogical Society is currently raising funds to try to have digitized all these War of 1812 bounty land files. They're rounding up the pension files. You can access those on Full 3, but they're going after the bounty land files next. If you want to request one, you use NATF Form 85. I'm going to give you an example of George Strother, which has a really interesting story in it. I was researching this guy for a talk I gave on his family, actually. And the story that's outlined here, he actually enlisted 3 times for brief stints during the War of 1812. He was single, so he just kept enlisting. And the last time they were going upriver, and put in, and he was one of the people sent out to hunt for the rest of the group. There were several of them, and he apparently went pretty far inland and was the last one back. And when he got there, they'd left. There was no boat to be seen. So he knew there was a fort nearby, and he walked to the fort, and he just stayed there until a few months later when the war actually ended. And then he found out later that the captain, Captain Yeaser, had actually dismissed the company when they got back to St. Charles. And so he didn't need to stick around anyway. So it's one of the few cases I can think of where the guy's company went AWOL and he was still on duty. Okay, by way of review, township school land, you'll find records at the county and state level, patent and sometimes register at the county level. You can find the records at the state archives, county clerk, county deed books. And you don't find a lot of real good genealogical information other than proof of original title. Kind of the same thing with seminary lands. The records are at the state level in this case, and saline and 500,000 acre, all the same. Patent at the state archives, either on microfilm or on CD. And possibly you'll find them recorded in the county deed books. Again, low value for genealogy except for proof of original title. Swamp and overflow lands, you'll find records at the state and county level, and probably more than any of these others at both. It generated a patent, a register, and in some cases, preemption proof. You're going to find the records of the state archives, county clerk's office, and county deed books. And if you can find one of these preemption files on an ancestor, really good information. Otherwise, low valued like the others, but you do get original title. War of 1812 reserve land, the Script Act of 1812. Federal Land Office is where you'll find the records. It's a patent that gets generated. You'll find the records in the National Archives, General Land Office, possibly county deed books, usually moderate information. In some cases, like if the veteran died, may be very high because his heirs cashed it in. Military bounty, Federal Land Office is where you'll find the records. And a warrant, a patent, and military bounty land file. You'll find it at NARA, General Land Office, possibly county deed books, and very high value genealogically. Details on military service, if the soldier died, relationships. And Homestead, Federal Land Office, a packet proving the qualification for homestead. You'll find the records in the National Archives, General Land Office, and possibly county deed books. Again, high value because proof files have family composition and other details. So with that, I'd like to thank Christina Miller, who's the senior reference archivist at the Missouri State Archives and knows more about Missouri land than any human being alive, and Mary Beth Niederkorn, who's a county archivist at the Cape Girardeau County Archives Center. And with that, I can entertain questions.
Okay, so starting off, an early question from Lisa asked, are any of these documents and records found at familysearch.org?
Unfortunately, for most of what I've talked about, you are not going to find them at Family Search, and I doubt that you're going to find them on Ancestry. You might find such things as lists of military bounty warrant numbers and that sort of thing. But for the most part, you really have to use the old-fashioned methods for researching some of these.
Okay. And then Lisa had a follow-up question. Can you speak at all to, was there a migration pattern for settlers fleeing the quake of 1811?
I guess it depends on your definition of fleeing. Congress granted certificates of relocation for people whose land was damaged by the New Madrid earthquakes. But for the most part, this became a scam. Most people, once the dust settled and the smoke cleared, realized their land wasn't that damaged, or else they'd moved on anyway. And so they sold their certificates to land speculators. And so if you want a settlement pattern, central Missouri, Missouri River, because that's where those land speculators located a lot of these certificates of relocation and actually started large farms. That's why you'll hear central Missouri referred to as Little Dixie. A lot of the basis for that is those certificates of relocation and that kind of land scam with New Madrid certificates. And a few of them were located here, there, and everywhere, but there were a lot of them located in the Missouri River bottoms.
Absolutely. The next question I see was from Sarah asking about the relation between Homestead Act and land grants to veterans. I think you kind of spoke to some of that. Was there anything else you wanted to say regarding that question?
I will say that, Civil War, there was no bounty land, but the Homestead Act was passed during the Civil War. And so there's no relationship directly, but the Homestead Act kind of picked up maybe where the bounty land warrants left off. There were still, military bounty land warrants cashed in after 1860, but not as many.
Good. As you can probably see here, the next question is from Richard. Was it possible that land speculators could acquire land under the Homestead Act in the case of Miami Purchase? And then, like I said, it might be faster for you to, to just read. Say they bought 640 acres and to improve it with time. Was there a similar process in Missouri?
Not to my knowledge. Yeah, not to my knowledge. The Homestead Act and land speculators, of all these acts, probably the one that was the least abused was the Homestead Act because of the pretty rigorous need for qualifying. And they had it was pretty spelled out that you had to do this, this, and this. And they would catch people trying to do speculator activity. A lot of these were not very speculator proof. If people can figure out a way to cheat on land stuff, they did.
Good to know. Richard also had a follow-up question. In your discussion of script warrants, how do you know which script warrant act to use for your research?
If you're not sure whether your ancestor served in a given war, I would just search individual ones one at a time. If you're pretty sure it was a certain war, just the script warrant acts related to that war. But again, I typically don't do that. I typically just uncheck patentee and search warranty. And then if you look at the patent image, it will tell you what war, and it will tell you what unit usually the veteran served in.
Next question was from Anne, who said that when she was looking at the history of a family farm, found reference to a position of it being designated in swampland, but not in the counties you referenced. Any thoughts or comments on that?
I think most every county in the state had at least some swampland. It might have been really restricted in some of the Ozark counties, but if you think about some of the river bottoms, there might have been some of that was designated as swampland. So, I mean, it's really prevalent in the Boot Heel, but I've seen swampland in Laclede County, for example, and it's prairie. It was just wet prairie, I guess.
Gotcha. Next question is from Rita, who was asking, one, does Fold 3 not yet have all the 1812 military bounty land grant applications? And then
it's pensions that they've been working on, and they don't have all the pensions up yet either. There's a few letters of the alphabet left, but they're going to be starting on military bounty land applications. And I think I've seen, just a few, but yeah, it'll be a while.
Okay. And so then with that in mind, the second part of Rita's question is how to best research what might be available at NARA.
Well, you can use the NARA website. You can set up a free account and search that. But for the most part, on these land records, you are not going to get right to them unless you have the rare event where some kind person has actually done research and scanned the file that you're interested in, and that's incredibly rare. I know when I was there, I just did one file, a pension file, just to use the facilities, just to say I'd done it, and that pension file is available for anybody that wants to find it. But for the most part, no.
The next question that came through was from Faye, who asked if slaves were used as collateral.
Slaves were property and had value. Yes, they were used as collateral.
Next question from Norman. Can you speak at all to how Spanish land grants were resolved?
Spanish land grants were resolved by a federally appointed Board of Land Commissioners. And this started in 1805. It was a three-person commission. The records and testimony, basic testimony to that commission, are on Family Search if you want to look them up. The only thing is, what will throw you is, you would think, well, I'll look under Missouri. No, look under Louisiana, because there was no Missouri territory when they started that. It was Louisiana. So it's under Louisiana land records. Yeah, and a lot of these claims were denied. So I don't know, some of them were denied unfairly, and that's why people kept going to Congress, and they actually convened a second commission, and they didn't resolve all these until the 1830s.
Gotcha. Okay. Just a few more questions for you, Bill, that we'll take live today before we wrap up. Margaret wanted to know if you could speak at all to why someone from Indiana would be migrating to far southwestern counties in Missouri in the 1840s.
Well, the land office had just opened up and land was available. And actually, if you look around Springfield, that's prairie land, and it's actually not too bad for farmland. So parts of Indiana were prairie. They might have been migrating to areas that just looked similar to where they'd been in Indiana. Yes, I'm looking at the last two. If you know your ancestor Missouri operated a ferry, is there any special place to research on information for that? Yes, indeed. They had to get a license from the state or the county, and those are recorded in county court records. Gotcha. Today we call them county commissions. And then hiring a local researcher at NARA, would they be able to search? Yes. But remember, you are paying for a service. I've used a guy that does military pensions and other records, and he's incredibly efficient and well worth the money.
This is the 16th installment, and if you have ideas for things that you would like discussed and covered, just send Bill a note and we will see if we can add a future installment to this fantastic series. All right. Well, thank you so much for joining us today, everyone. Thank you, Bill, for this wonderful program, and I hope everyone has a wonderful day.